Good day, ladies and gentlemen, and welcome to the continuation of our discussions on the Executive Department, Article 7 of the 1987 Philippine Constitution. Now, in political systems based on the principle of separation of powers, authority is distributed among several branches. Of course, we know them: the executive, the legislative, and the judicial branches of government. An attempt to prevent the concentration of power in the hands of a single group of people or a single individual. In such a system, the executive does not pass laws, which is the role of the legislature, nor interpret the laws, which is the role of the judiciary. Instead, the executive enforces the laws as written by the legislature and interpreted by the judiciary. This is the function of the executive department and the concept of what executive power is. Now, Section 1. The executive power shall be vested in the President of the Philippines. What is executive power? Executive power is defined as the power to administer the laws, which means carrying them into practical operations and enforcing their due observance. Now, who wields the executive power? The Constitution vests executive power only to the President. He is therefore not merely the chief executive, but rather he is the executive, the only executive. In other words, now a chief executive pertains to the most senior corporate executive or administrative officer in charge of managing an organization. This means that there are other executive officers who share in the exercise of the executive's power. This is not so in our form of government. There is only one executive who wields executive power, and that is the President. How about the members of the cabinet? Do they not exercise executive power? No, they do not. They are merely the conduits by which the President exercises executive power. They do not actually exercise executive power. The members of the cabinet are the President's alter ego. Under the principle of qualified political agency, and it is by this relationship why we say that only the President exercises executive power. However, it has been a practice in our form of government that we refer to the President as the chief executive. The President is also at the same time the head of state. And what is the significance of such title? Previously, and in other jurisdictions, the head of state is merely a ceremonial in character, like an emperor or queen in a constitutional monarchy. In our form of government, the President, as a head of state, is actually the head of the government. It is as a head of state that he wields political and executive power. Section 2. No person may be elected president unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, and at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. It is of note that the Constitution does not actually require the President to be the holder of a degree. But the expectation, of course, is that the President is sufficiently learned to lead a country of 110 million Filipinos. It seems the Constitution allows the people to choose as to whether they wish to have a president who may not have a high degree of education. In history, most of our presidents were lawyers. Even our current president is a lawyer, with the exception of probably Corazon Cojuangco Aquino, the president dubbed as the housewife. but who herself has a degree from a college in the United States. And probably the exception would be Joseph Ejercito Estrada, but his stint in local politics as a mayor and as a senator would have given him the necessary tools to navigate through the political environment of the office of the president. There is also no character requirement, unlike what is required of members of the Lupong Tagapamayapa. Now remember that the Lupon, no, the members of the Lupong Tagapamayapa are tasked with conciliating conflicting parties in the barangays, the smallest political unit of our government. Now the members of the Lupon are required by law to possess integrity, impartiality, independence of mind, sense of fairness, and reputation for probity, which is under the local government code. And this is not, of course, required of the president. Section 3. There shall be a vice president who shall have the same qualifications and term of office and be elected with in the same manner as the president. He may be removed from office in the same manner as the president. And the vice president may be appointed as a member of the cabinet, and such appointment requires no confirmation. The vice president is constitutionally the first in the presidential line of succession. The Constitution provides several circumstances where the vice president or the vice president-elect shall assume the presidency or serve as acting president. Now, they are saying that the president is merely a reserve president. But during the vice president's tenure, the vice president may be appointed as a member of the cabinet, and such appointment requires no confirmation. Now remember that the members of the cabinet shall first hurdle the Commission on Appointments. Now this is what it means in the last statement, that the appointment requires no confirmation. So there is no confirmation that is required of the vice president who has been appointed to a cabinet position by the Commission on Appointments. Section 4. The president and the vice president shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election and shall end at noon of the same date 6 years thereafter. The president shall not be eligible for any re-election. No person who has succeeded as president and has served as such for more than 4 years shall be qualified for election to the same office at any time. The President of the Philippines is elected by direct vote of the people. And his term is only for 6 years with no provision of re-election. However, after his or her term, he may be elected or she may be elected to lower positions. And these instances have happened in the past. As regards former President Gloria Macapagal Arroyo, who later ran and was elected for a seat in the House of Representatives, or even President Joseph Ejercito Estrada, who would later again run and be elected as the mayor of Manila. No vice president shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which she was elected. Now, the Vice President of the Philippines is also elected by direct vote of the people, with a term also of 6 years. The Vice President may serve for not more than 2 successive terms, and therefore you can re-elect a sitting Vice President. But that particular individual, that the vice president, may serve for not more than 2 consecutive terms. The vice president, despite having served for 2 successive terms, may run for the presidency, and of course for lower positions in the government. Unless otherwise provided by law, the regular election for president and vice president shall be held on the second Monday of May. Now, this is, of course, a particular provision which is similar also to um, the election for the office of the members of the House of Representatives and the Senate. Now, they are elected on the second Monday of May, which is actually the regular date for national elections, national and local midterm elections. By the way, what is the reason for the prohibition against re-election? Okay, against the president, no, vying for the seat, for another term. Now, it is contended that if the president is allowed to run for re-election, the president might devote himself to being re-elected instead of concentrating or performing his duties as the president of the republic. Secondly, the president might use public funds to maintain power, either by directly using government funds or using government funds for projects to cull favor from the people. And a prohibition against re-election may also put an end to political dynasties. Now, political dynasties, of course, requires a definition in law in order to really for us to determine what political dynasty is. Now, 6 years is also said to be sufficient time for the president to implement his plans and programs of government under the platform under which the president ran during the election. Okay. So Section 4, pertains to the returns of every election for president and vice president, duly certified by the board of canvassers of each province or city, shall be transmitted to Congress and directed to the president of the Senate. And upon the receipt of the certificates of canvass, the president of the Senate shall not later than 30 days after the day of their election open all certificates in the presence of the Senate and the House of Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof, in the manner provided by law, canvass the votes. So it appears here that under the Constitution, the Commission on Elections does not have a particular participation in the canvassing of the votes for the president and vice president. So the returns of every election, duly certified by the Board of Canvassers of each province or city, shall be transmitted to the Congress. In the case of Brillantes versus Comelec, GR number 163193, the Supreme Court said that there is no constitutional or statutory basis for Comelec to undertake a separate and an unofficial tabulation of results, whether manually or electronically. By conducting such unofficial tabulation, the Comelec descends onto the level of a private organization spending public funds for the purpose. This not only violates the exclusive prerogative of NAMFREL to conduct an unofficial count, but also taints the integrity of the envelopes containing the election returns and the election returns themselves. Thus, if the COMELEC is proscribed from conducting an official canvass of the votes cast for the President and Vice President, the COMELEC is, with more reason, prohibited from making an unofficial canvass of said votes. Still under Section 4, the person having the highest number of votes shall be proclaimed elected, but in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress voting separately. So in the event of a tie, no, as regards the office of the president and the vice president, no, in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress voting separately. Congress shall promulgate its rules for the canvassing of the certificates, and the Supreme Court, sitting en banc, shall be the sole judge of all contests relating to the election returns and qualifications of the President or Vice President, and may promulgate its rules for the purpose. The Supreme Court therefore sits as the Presidential Electoral Tribunal. Section 5 is the prescribed oath, for the President and the Vice President. Before they enter on the execution of their office, the President, the Vice President, or the acting President shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as President or Vice President or acting President of the Philippines, preserve and defend its Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. Section 6 are some of the privileges enjoyed by the President. The President shall have an official residence. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent, during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. Section 7. The President-elect and the Vice President-elect shall assume office at the beginning of their terms. If the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. If a President shall not have been chosen, the Vice President-elect shall act as President until a President shall have been chosen and qualified. If at the beginning of the term of the President-elect shall have died or shall have become permanently disabled, the President-elect shall become President. And where no President and Vice President shall have been chosen or shall have been qualified, or where both shall have died or become permanently disabled, the President of the House, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or Vice President shall have been chosen and qualified. So this is the order of succession. No? Important to note is that where there is no President or Vice President, or both have died or become permanently disabled, it is the President of the Senate, or in the case of his inability, the Speaker of the House of Representatives shall act as President. The Congress shall by law provide for the manner in which one who is to act as president shall be selected until a president or a vice president shall have qualified in case of death, permanent disability, or inability of the officials mentioned in the next preceding paragraph. No. So if you look at the last part of this statement, it appears that what if the president dies or is incapacitated, no, if there's permanent disability, or in case of death of the president, the vice president, even the president of the Senate and the Speaker of the House, okay, all of them die. Who shall now assume or act as president until a president or vice president shall have qualified? Okay. The Constitution is silent about that, but the Constitution directs Congress to make a law, no, in order to address such particular situation. It may be far-fetched, but no, it can happen. Now, this is the meat of the bill passed by Senator Lacson, no, or what would happen if all these individuals, no, who are constitutionally mandated to act as president, no, dies or become permanently disabled. So that is the content of the bill of Senator Lacson. I think that their proposal would be, the most senior senator, depending on the number of years that that particular senator served, followed by the most senior member of the House of Representative, depending on the number of years that particular individual has served as a member of the House. Section 8. In case of death, permanent disability, removal from office, or resignation of the President, the Vice President shall become the President to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both the President and the Vice President, the President of the Senate, or in the case of his inability, the Speaker of the House of Representatives shall act as President until the President or Vice President shall have been elected and qualified. There have been 4 cases where the Vice President has assumed the presidency, 3 of which because of the President's death and 1 because of the President's resignation. We have the case of Vice President Sergio Osmeña in 1944, becoming the President upon the death of Manuel Luis Quezon. We have Elpidio Quirino in 1948 upon the death of Manuel Rojas. Carlos P. Garcia in 1957 upon the death of Ramon Magsaysay. And Gloria Macapagal Arroyo in 2001 upon the resignation of Joseph Ejercito Estrada, which was, of course, decided by the Supreme Court, where it said that President Estrada did resign. Section 8 still, the Congress shall by law provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He shall serve until the President or the Vice President shall have been elected and qualified and be subject to the same restrictions of powers and disqualifications as the acting President. In Section 9, whenever there is a vacancy in the office of the Vice President, during the term for which he was elected, the President shall nominate a Vice President from among the members of the Senate and the House of Representatives, who shall assume office upon confirmation by a majority vote of all the members of both houses of the Congress, voting separately. So, when the Vice President dies or becomes permanently incapacitated, there is no automatic assumption by the President of the Senate nor by the Speaker of the House, but rather the President during his term shall nominate a Vice President from among the members of the Senate and the House of Representatives, who shall assume, no, the office, but upon confirmation by both houses. Section 10. The Congress shall at 10 o'clock in the morning of the third day of the vacancy in the offices of the President and Vice President occurs convene in accordance with its rules without need of call, and within 7 days enact a law calling for a special election to elect a President and a Vice President to be held not earlier than 45 days nor later than 60 days from the time of such call. The bill calling such special election shall be deemed certified under paragraph 2, section 26, article 6 of this Constitution, and shall become law upon its approval on third reading by Congress. Appropriations for the special election shall be charged against any current appropriation and shall be exempt from the requirements of paragraph 4, section 25, article 6 of this Constitution. The convening of the Congress cannot be suspended nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. So, if the vacancy occurs earlier than 18 months before the date of the next presidential election, there should be a special election called for the office of the President and the Vice President. But after that, no special election shall be called. And therefore, the person acting as President shall serve as President until the next election.